Welcome to Divorced from Reality with Johnny Bardine.
Welcome to Divorce from Reality with Johnny Bardine. Johnny is a dedicated attorney who has been serving the Tampa Bay community for over a decade with a mission to help individuals and families through their most challenging times. Johnny provides compassionate, fierce advocacy in all matters family law. I'm your host, Lisa Mosby, and today we're talking about how property and finances are divided in Florida divorces. Welcome, Johnny. Thanks for being with me again today.
Really good to be here. Thank you so much.
Yes. When a marriage ends, one of the first worries is who keeps what in Florida. That process is called equitable distribution. Can you explain what that really means for couples dividing their assets?
Yeah, sure. It's governed by statute. Equitable distribution really just means splitting up your assets and liabilities in divorce. And the general rule in Florida is that everything that's accrued from the date of the marriage until the filing of the divorce is going to be marital property and subject to equitable distribution. And the presumption that we start at is that it's 50-50, that it's going to be an equitable distribution. And one important note is that things that were accrued, debts and assets prior to the date of marriage, are going to be separate marital property, but their appreciation during the course of the marriage is going to be subject to marital property. For example, if I owned a house and then I got married and my wife moved into the house, that house would be non-marital property. I would retain ownership to it, but what happened to the value of the house during the course of the marriage is going to be marital property and subject to equitable distribution.
That's clear. I understand that. And then what are some examples of assets that commonly create confusion? Things like maybe retirement accounts or a small business.
Both of those, right? The retirement accounts, for pension plans, 401ks, those are often prone to confusion because one person had worked in this job and they're saving money in an investment account for that job. They think they're entitled to all of it, and they're not. And so what's happened to that retirement account during the course of the marriage is actually marital property. And then, like you mentioned, the small business distribution is incredibly complicated because what are the going concerns of that business? Who's going to run it? Usually that's the livelihood of one or both of those parties. So someone is either going to have to run it afterwards, or they're going to have to jointly decide to sell it. And selling a small business is tough. Tough in this market. It's tough to evaluate. It's expensive to evaluate. And I think those two items are probably the most complicated items in equitable distribution, which is generally not a terribly complicated area of the law.
And we've mentioned equitable distribution a couple of different times. Does equitable always mean 50-50 split, or are there situations where one spouse could receive more than the other? When would that apply?
Yeah. Right. So equitable distribution doesn't mean equal. It means fair. And the presumption in the statute is that there's going to be an equal distribution of it. And so to get to that number, you kind of dump in the assets and liabilities in a bucket and you split it in half and you figure out how to equalize that, right? But there are instances in which one party would be entitled to inequitable distribution, so more than 50%. And those cases are very fact specific, and you've got to plead them very specifically, and they usually involve instances where one party has secreted assets or made financial decisions on behalf of the other party without telling them, and things like that. And when that occurs, and then the party who's been wronged can get more than 50% of the asset.
So what factors do judges look at when dividing property? For example, like income, contributions to the marriage, childcare responsibilities, or something else I might be missing?
Well, there are a number of factors that are indicated in the statute for how the court's going to determine how those assets and liabilities are going to be divided among the parties. But the first thing that parties will have to do in a case is file a financial affidavit, and then the supporting documents that substantiate that affidavit, called mandatory disclosure. And so that's going to have to completely and conclusively list the assets and liabilities of the parties and the financial circumstances of the parties. And part of that is going to have to be when that asset or liability was accrued, and how much of that happened during the marriage. But there is a justification for unequal distribution, and there are a number of factors indicated in the statute, and that has to do with the contribution to the marriage by each spouse, including contributions to the care, education of the children, the economic circumstances of the parties, the duration of the marriage, any interruption, personal careers of either party, and desirability, or like who wants to retain an asset, and that could be a business, a corporation, or marital home, and that is going to be a factor that the court relies on, along with the what one of the parties might have done to acquire or enhance the or improve the asset or liability subject to equitable distribution.
Okay. And Johnny, if a couple reaches their own agreement about dividing assets, can that be approved by the court as long as it's fair, or does the judge still have to make changes or weigh in on that?
That is a good question, and yes, I mean, look, these cases get decided in one of two ways: either the parties agree or the court decides. And we're not always going to like how the court lands on that, and we don't have very much control over it. But the good news is that throughout these cases, the parties have a lot of opportunities to try to resolve it, and the court is going to be inclined to ratify that agreement. It's not like a parenting plan with minor children with time sharing. For those, it's good for the parties to agree, but then the court is going to have to ratify whether that's in the children's best interest. So that's generally not an issue in the property division, and the court's going to honor how the parties resolve that.
And where do debts fit into this whole process? Can things like credit cards, student loans, or the mortgage be divided just like assets?
Exactly like assets. So
Okay.
and debts that are accrued, liabilities that are accrued during the course of the marriage are going to be marital property too, even if they only benefited one person. And the best example and most common example is the one that you mentioned, which was student loans. So the student loans that were taken out and used during the course of the marriage are going to be marital property, even if only one person went to dental school or whatever they're using it for. So
That's interesting. Emotions can run really high when people are deciding who keeps the house or the sentimental property. How do you help clients stay level-headed and focused on the big picture during the negotiations?
that's difficult too. And so sometimes time helps, and the longer these things go, I think the emotional temperature can come down, and people can make better decisions, because the division of the equitable distribution stuff is just a business decision, and it's something that the courts have a pretty good process on, a fair process, and so there's not a whole lot of creativity here. So, so I think the most challenging part of my job, and something I try to be really good at, is managing client expectations, and getting that done on the front end, and getting the clients to understand their potential leverage and exposure, and also a cost benefit analysis. If you're upset that you want $10,000 more from an IRA, then I'm going to talk to you about what the cost of litigating that issue is going to be, and maybe the cost of it outweighs the benefit.
For someone who's just starting the divorce process right now, what's the smartest thing they can do to prepare financially before the property division and negotiations begin?
What you should not do is change your behavior of what you've done traditionally during the course of the marriage. So what the parties have been paying for is important, and that should continue, because I think if you, for example, take someone off the health insurance, that could come back and harm you in the context of the divorce. And so, but what you need to start doing, I think, is understanding that a divorce is going to mean a short-term change in your financial circumstances, and usually for the worst. So that understanding, and then also doing things that are going to help you, which is try to do your best to lower your personal overhead, at least for some period of time. Refrain from moving assets to other accounts without discussing that with a lawyer or getting the permission of the other party, and also getting your documents together that are going to help me make the best case for you.
And I think we'll leave it there, Johnny. Thank you for all these great tips today.
Thank you so much. Thanks for having me.
And folks, thank you for listening to Divorced from Reality with Johnny Bardine. For more information or to connect with Johnny, visit bardinelawfirm.com. Don't forget to like, subscribe, and share this episode if you know of someone who might need it today.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.